We're going to talk about the federal law protections that are going to apply or you should consider. Next slide, Taylor. So the main one is going to be Title VII. This is Title VII of the Civil Rights Act of 1964. This is protections for individual against discrimination regarding race, color, religion, sex, and national origin. This applies to any employer who has more than 15 employees at least 20 weeks out of the year. So this isn't protection for the smaller businesses. This is federal based. This is for at least 15 employees out of the 20 weeks. There is no minimum size for the employer requirement if it's regarding an employment agency. A labor organization falls under Title VII protections if it does have more than 15 members. Title VII prohibits discriminatory practices regarding compensation, terms and conditions of employment, or privileges of employment. This is defined in many cases, what exactly is terms, conditions, of privileges. A lot of, you can get into harassment-based claims as well as discrete acts like non-selections, terminations, other type of suspensions. Those types of acts would be discrete actions. But it also includes things like, the individual's pay was decreased. They were, subjected to changes in their employment duties. They were given assignments more than others. They were micromanaged. Or they were, say, taken duties away from them. So all of that would fall under possible discrimination claims. Title VII also protects against retaliation. Retaliation would be for protected activity under Title VII. So if an individual, say, opposes discrimination or harassment, they went to their supervisor. This is very broad. They went to their supervisor and they are claiming that they were targeted because of their race. That would be protected activity that Title VII would protect them from. They would also be protected from actual charges being filed. So say an individual filed a complaint with the Equal Employment Opportunity Commission. That would be an action that would be protected by retaliation, as well as, we'll get to it, New York State Division of Human Rights, other types of charges they engaged in a complaint in state court. All of those would be falling under protected activity for purposes of Title VII. What's important to remember is not all protected activity an employee engages in is protected as actions under Title VII. So say someone files an OSHA complaint, they're not bringing up harassment, but they're bringing up safety concerns. That's not protected activity under Title VII. So retaliation component of the act would not protect them regarding filing a claim. It would be important to remember that Title VII, while it does not have the minimum requirements and the labor organization falls within it, it does not apply to religious organizations. This is corporations, associations, educational institutions, and societies with respect to employment of individuals of a particular religion, sex, or national origin. Title VII also does not apply to American companies employing foreigners outside of the United States or American companies doing business outside of the United States if a local law will conflict with it. Title VII does not protect communists and other protected or other related activities, and it does not prohibit preferential hiring practices towards Native Americans. If we can go to the next slide, Taylor. So to establish a claim of discrimination under Title VII, there's two claims that you can bring, disparate treatment and an impermissible motivating factor. Disparate treatment is determined based on a two-part test. First, an individual must show that the employer utilizes a particular employment practice that causes a disparate impact on persons on the basis of race, color, national origin, sex, or religion. So this is where it's multiple individuals. This employment practice impacts these protected bases versus others. It's not necessarily just that it's affecting that individual on their protected basis. After showing that they utilize a particular employment practice, then the employer must demonstrate that the employment practice is related to a particular job in question and consistent with business necessity. The next would be motivating factor. This is where it seems a lot of cases get into it. Motivating factor is you're demonstrating that the reason why an employment action was taken was because of a discriminatory motive. A lot of the cases I tend to see are regarding impermissible motivating factor, and there's going to be a burden shifting analysis that a court will do, EEOC or a state court or even federal court. So for a motivating factor, the seminal case on this would be McDonnell Douglas Court versus Green. This is an old case. Supreme Court of the United States established the burden shifting framework. First, a claimant or a complainant must establish a prima facie case. So there's 4 requirements. 1, the individual belongs to a protected group. That would be an individual identifying their protected bases. So for Title VII, we're talking race, color, religion, sex, or national origin. After establishing that they are part of that protected group, you would move on and try to establish that they applied for or were qualified for the position that they are dealing with. So McDonnell Douglas was specific to non-selection and other issues. This is also regarding you're going to establish that they are qualified for their job. They're able to perform the essential functions. The other portion of it is that, sorry, let me rewind a little bit. I'm getting ahead of myself. McDonnell Douglas was specific to a non-selection. So we are going beyond that. We are getting into the burden shifting framework. We're going to show that the case is where you are demonstrating that there's a protected group. The second is that there was an adverse action taken. Adverse action, we're getting into, again, going back non-selections, removals, suspensions. We're also getting into actions taken. So if there's harassment, that's a different burden, but you're demonstrating that there were actions or non-actions by the agency. The third element is you're going to connect the adverse action to the protected bases. So there was some sort of nexus between the two. There's some sort of motivating factor. And then the fourth is that there was liability on the agency. This is where the company management was aware that the of the improper actions. It was an action taken by management, a supervisor, someone above, and that liability should be imputed into the agency. After the claimant or the complainant establishes their prima facie case, the burden shifts to the employer. The employer must establish that there are legitimate, non-discriminatory or non-retaliatory reasons for the actions. This could be using a policy was followed, a specific objective process if it's a selection. The burden is on the employer. The final burden then shifts back to the complainant in these cases. The complainant will have to establish that these non-discriminatory legitimate reasons that the employer is putting forward are just pretext. That there is evidence that this legitimate reason, either the process wasn't followed, that there are comparators, there are comparator evidence to bring forward and show that they did the same thing regarding this individual who was within the protected class, or even that someone else who was outside of the protected class was treated better. This type of evidence can all be used towards establishing pretext. A lot of the times, this looks a lot like establishing nexus, which is part of the prima facie case that a claimant has to bring up or has to demonstrate. But it is different because you are specifically targeting the legitimate reasons, and you're using additional evidence to demonstrate that they're inaccurate. To remember for recovery, because a lot of the times clients are going to discuss with you about what they can get out of their pace if they move it forward. Recovery is limited under Title VII. Compensatory damages is going to be limited by the size of the employer. So I get a lot of questions about that McDonald's case that they ended up winning $15 million for, and whether or not they can get that. One, always establishing that those cases, there's usually other claims involved is important. And what exactly the 15 million is coming from is very important to discuss too, because under Title VII, it is limited. So if we're talking about an employer who has between 15 and 101 employees, compensatory damages, pain and suffering damages are capped at $50,000. If we're talking about an employer who is between 100 and 201 employees, the damages are capped at $100,000. 200 to 501 employees, the cap is $200,000. And anybody who is over 500 employees, the cap is $300,000. For those who do federal sector, the cap in general for any claim you might file under Title VII for a federal employee is going to be $300,000. Other damages you could get under Title VII would be back pay for up to 2 years preceding the filing of the charge. So if someone, say, filed a discrimination complaint regarding a termination, and it takes the length of the case to go forward, to get before a judge, to litigate, it'll be up to 2 years preceding the filing of the charge. You could also seek to enjoin the unlawful employment practice being done, and there could also be other affirmative action. So if there's a suspension, the suspension could be removed. There could be clean records taken, leave restoration, any type of action that's directly related to the claims in the case. If we can go to the next slide. Another federal law to be aware of would be the Americans with Disabilities Act. ADA prohibits employers from discriminating against qualified individuals on the basis of disability, again, regarding the terms, conditions, and privileges of employment. This is also regarding employers who have a minimum of 15 employees for 20 or more weeks out of the year. The ADA does not apply to individuals who are employed by the federal government. That I would direct you, and this we will not discuss, but I will direct you to the Rehabilitation Act for how the ADA would apply to federal employees. Under the ADA, a qualified individual is defined as an individual who, with or without reasonable accommodation, can perform the essential functions of the employment position held or desired. Deference is given to the employer's judgment as to what functions of the job are essential, and if an employer's advertised written description shall be considered evidence of the essential functions of a job. So if you post, we are expecting this individual to be doing X, Y, and Z, and all of a sudden they're adding 6 different employment duties, that can be definitely up to debate on whether or not it's an essential function. A disability is a physical or mental impairment that substantially limits one or more major life activities. You can use this with a record of such impairment actually existing or being regarded as having an impairment. A lot of the times there's a request for a medical note, some sort of medical record that shows that this individual, upon a doctor's recommendation, cannot perform whatever it is, sitting for long periods of time, standing, those types of behaviors. Major life activities can include, but certainly are not limited to, caring for themselves, performing certain manual tasks, sight, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, being able to read, concentrate, communicate, any type of major function. Major life activities could also include operation of a motor vehicle, those types of activities as well. You could include in there immune system response, cell reproduction, digestive system, urinary system, nervous system, respiratory issues. Really, it's a very broad inclusion. Employers under the ADA must provide qualified disabled employees with reasonable accommodations for the employee's known disability at the employer's expense, unless the employer can show that the accommodation would impose an undue hardship. Reasonable accommodation is not explicitly defined in the law, but may include modifications to existing facilities, making them accessible or usable, acquisition of new facilities or devices to make accessible or usable by the individual with a disability, job restructuring, modifying their work schedules. They could go into part-time, flex time. They work a different shift. If they have difficulties driving in, there's remote work. Is definitely more prevalent now because of COVID and the switching of mindsets there. It includes, as a possible last resort, a reassignment or other types of movement for their positions. An accommodation is unduly burdensome when it requires significant difficulty or expense considered in light of the nature and cost of the accommodation, the financial resources of the employer, or the financial resources of the facility, the number of persons employed, the impact the accommodation will have on the facility, the types and methods of operations of the employer. So this is a case-by-case kind of analysis with reasonable accommodations. It's definitely not a one-size-fits-all, but that type of argument, right, if we're talking about a corporation with over 500 employees in multiple cities, what can they afford versus someone who has 15 employees and they're only located in one city, and you know, what can they afford? What can they do if they don't have a brick and mortar versus someone who's fully remote? Obviously, different accommodations apply for different positions, different employers, different facilities. Under the ADA, in terms of what a complainant must demonstrate, they must demonstrate that, one, the employer is subject to the ADA, that they do have a disability within the meaning of the law, that they are qualified to perform the essential functions of their job with or without an accommodation, and an adverse action was taken because of their disability. Similarly, there is caps and different types of damages that can qualify under an ADA for a claimant. There is compensatory damages, back pay up to 2 years. They can also enjoin under the ADA and join the unlawful employment practice, could order appropriate accommodations to be taken. Compensatory damages are reserved for claims where the employer acted with malice or with reckless indifference to the federal protected rights. The caps for compensatory damages, very similar in nature to Title VII, but I'm going to just read them off again. 14 to 101 employees is going to be cap of $50,000. 100 to 201 employees, $100,000. 200 to 501 employees, $200,000, and anything greater than that is a $300,000 cap. If we can go to the next slide, Taylor. Next slide. Another federal law to be aware of is going to be the ADEA, Age Discrimination Employment Act. Federally, this is protections for anybody over the age of 40 from discrimination based on age. It's similar to Title VII, again, also similar to the ADA. However, it's not just Title VII, it's not just the ADA. It is, in this case, instead of 15 employees per company, this is to have the ADEA apply, it's 20 or more employees. There are no compensatory damages or punitive damages under the ADEA. What you could be entitled to are possible double liquidated damages if you do establish willful behavior. Under the ADA, it does also establish minimum requirements for pensions, certain types of employment at employees for certain ages. There are also prohibitions on mandatory retirement ages across most sectors, not all, but most. If we can go to the next slide. Another and the final federal law that I'm going to cover today is the Family and Medical Leave Act, FMLA. This is codified under Chapter 29 of Title 29 in the U.S. Code. The Family Medical Leave Act requires covered employers to provide employees with certain lengths of unpaid leave or leave for qualified medical and family reasons. The covered employers are required to allow employees returning from family or medical leave under the law at substantially the same job status they were in at the time he or she left. Under the law, an employee is entitled to up to 12 weeks during any 12-month period. This is not necessarily a calendar year. If someone applies for FMLA in August, they take 12 weeks, and then all of a sudden, they would be able to take another 12 weeks beginning the 1-year anniversary. So if we're talking, they take it in August, they would be able to start taking another 12 weeks beginning August of the following year. Permissible reasons can include the birth of a son or daughter, placement of a child with the employee to foster or adopt, to care for a spouse, child, or parent, if there's a serious health condition, if the employee has a serious health condition. And then also for any qualified emergency, such as those related to a family member's deployment. So this is important when talking to service members. If they're active duty, there's a possibility if they're called unexpectedly, their spouse or other person of their family, if they're all of a sudden required to care for a child or a parent, or some other next of kin, they will be entitled to 12 weeks during a 12-month period of time as well. The amount of time is different if you are a military caregiver. So if an individual returns, say, from active duty, they are injured, you are able under the Family and Medical Leave Act to require up to 26 weeks during a 12-month period of time if you have to care for a spouse, child, a parent, or next of kin as well, if they return from deployment with a serious medical condition. Employees, again, are entitled to be restored to the position they held prior to the commencement of the leave, or an equivalent position with equivalent pay, benefits, and terms and conditions of the employment. Employers are required to protect benefit accruals while the employee is out on leave. They're not required to let them to continue to acquire leave, but they do have to protect they basically have to be restored to the same exact position they were in when they left. They do have to continue as if they are employed in terms of their insurance, so they can't take them off their insurance, even if they're being in a leave without pay situation. They also are prevented against retaliation under FMLA. If we can go to the next slide. So if there is a violation of FMLA, or if there's retaliation because an individual used FMLA, for instance, they say you took FMLA, you were returned to a position other than the one that you previously held. They are adding additional duties to you. They are taking away duties. They are trying to put you in a substantially lower position, whatever the case may be. You could file a complaint with the United States Department of Labor. This would be an allegation of retaliation for the use of FMLA, or say if the employer is not enabling the individual to use FMLA, you can also file a complaint with the DOL at that point. There are, under the statute for FMLA, there are also different types of damages that can be recovered. And if the employer cannot show a good faith belief with reasonable grounds for the denial of the leave, then the employee is entitled to double damages. Okay, next slide, Taylor.
So we're actually going to take a moment and pause to read off the first course code. So the first code is going to be 296843. Again, that's 296843. And I'll leave that up on the screen for a moment for everybody to copy down. All right, Amanda, we should be good to move on.
Okay, we can go to the next slide. All right, so now we're going to move into New York State. We can go to the next slide too. Okay, so New York State human rights law. There is now a New York City human rights law. I'm just going to touch on the New York State human rights law. This is Article 15 of the executive law, specifically in Section 296. It does provide, generally speaking, I will say it's very similar to Title VII. It does provide a choice of law. You can either file in with the New York State Division of Human Rights, or you could go right to state court. Now, and I'll get into this when we talk about possible options. And the deadlines, though, for filing such complaints do tend to match up now. For New York State, it's much more expansive than federal. It does include, as you can see on the screen, much more protected bases. We are talking about an individual's age, race, creed, color, national origin, sexual orientation, military status, sex, disability, predisposing genetic characteristics, marital status, familial status, citizenship or immigration status, gender identity or expression, or domestic violence victim status. One thing to note for New York State, it is an 18 years of age for age discrimination, not 40 years like under the federal law. There are also federal laws that do protect things like military status. However, New York State human rights just put it all in one place. Again, this is where it protects an individual from any type of discrimination for compensation, terms, conditions, or privileges of employment, a refusal to hire or employ, termination, or any such other similar action. If we can go to the next slide, Taylor. This does also protect against retaliation, New York State human rights law. It does also require employers to provide reasonable accommodations for any employee's physical or mental disabilities, unless a very similar burden that they can show an undue hardship on the employer's business. There also is a determination under the law when employment interference with religious practices rises to a level of an unlawful discriminatory practice. So again, it touches a lot on the same federal laws, same issues that federal law we just discussed. An employer is obligated to make a bona fide effort to reasonably accommodate an employee's religious needs unless such an accommodation will cause undue hardship on the conduct of the employer's business. So getting into what rises to the level of religious discrimination, the law does go through. In the case of holy days or Sabbaths, the employer may elect to consider time off for holy days as paid leave, not sick leave. Have the employee make up the hours at another time without the right for commensurate pay, or taken as unpaid leave. If we can go to the next slide. So those are the laws, just a general basic overview. We're going to go into the complaint options. So what processes you could consider with filing for federal agencies and New York agencies. Next slide. The first option you do have is filing a claim with the EEOC, the Equal Employment Opportunity Commission. If you do file, I will say this, if you do file with the EEOC or you choose to file a New York State Division of Human Rights complaint, there is such a thing as contemporaneous filing. So the EEOC will also open up a charge if you file with the division, and the division will open up a charge with the EEOC if you decide to go there first. An individual may not file a complaint with the commission until the earlier of 60 days after commencement of proceedings under state or local law, or until state or local claim is denied. A complainant must file his or her complaint with the commission on or before 180 days or 6 months after the alleged illegal employment practice occurred. If the employee was if a complainant was required to file proceedings in state or local courts first, then that period is modified to the earlier of 300 days or 30 days after the denial of the state or local claim. This is a very complicated subject. This is just an initial basic overview to make you aware that there are certain types of deadlines that come into play depending on who the complainant works for, as well as local or state laws that do apply. So it's very important to consider both federal and state laws when you are considering deadlines for filing a complaint for an individual. When you file a charge with the EEOC for any time you are filing a complaint on behalf of an individual, there are specific forms that an attorney would fill out. I believe now the EEOC also has a specific portal for attorneys to use in filing charges. It is a simplified charging system and notice that we would be required. I believe it's a Form 5 that should be located on the EEOC's website that you can use to complete. When you file the charge, you file it with the EEOC, and the EEOC will notify the employer of the complaint. The commission, when you file the charge, it will trigger the commission's own investigation, and they will go through, and really it's up to the specific investigator assigned on how they will process it. There are different tools that they may use. Most often is where you're provided the response by the employer, and you get a chance to rebut any of the information provided. They may also ask for specific follow-up information or supplemental information. If, as a result of the investigation, they find no reasonable cause to believe the complaint is true, the commission will issue a determination letter to the complainant, and it'll include a right to sue. A right to sue will give them 90 days to file in federal court a complaint to basically continue the civil litigation. So it's not necessarily the end, it's just the end where the commission has said they're not going to continue the case beyond the investigation. If there is reasonable cause, the commission will charge itself to eliminate the discriminatory practice. They may employ methods like conciliation, which is a fancy word for mediation. They're going to try to bring some sort of resolution with the employer if it's possible. All discussions held at any type of conference or discussion about conciliation are confidential, would not be admissible into court. The commission does have 120 days to render its determination regarding the reasonable cause to believe if a complaint is true. Any point thereafter, you could request that the commission issue, say your client doesn't want to wait, you could request that the commission issue a right to sue letter. Next slide. If the commission has taken up the charge, if they're not able to resolve it in any way with the employer, the commission is able to commence a civil action against the employer in state court. For government employers, the commission is required to hand the case over to the Attorney General's office to pursue the claim. That's where you would make some sort of intervening motion to be able to get into the civil claim in court. The complainant may also maintain a private right of action if the commission denies his or her complaint after the passing of 180 days following the filing of the complaint. As far as damages, the commission's procedure, you can seek injunctive relief. This would be any type of claim that's connected to, or any type of damage that's connected to the claims that are raised. You can also seek, again, lost wages going back 2 years, so going back into Title VII and ADA requirements on damages. If you proceed to court and you are the prevailing party, you are entitled to attorney's fees. Next slide. So other than the option of filing with the EEOC, you do have the option of filing with the New York State Division of Human Rights. You are not required to file with the division to raise a discrimination claim under the New York human rights law. You can go right to state court. The division can hear all complaints against employers in New York State, with itself being the only exception. They have a different process to follow. The complaint, this is where it's different. The deadline for any action that occurred on or after February 15th of 2024 has 3 years to be filed with the division or in state court. If an action, the most recent action, occurred before February 15th of 2024, the deadline is 1 year to file. There was a recent amendment that went into effect February 15th of 2024, and it modified the deadline. This is for any claim of discrimination. Since August 12th of 2020, sexual harassment claims to be filed with the New York State Division of Human Rights has been extended to 3 years. As far as filing a claim in state court, the deadline is 3 years. So say an individual, something happened, the most recent action is on January 15th of 2024. You'd have a year to file with the division. You would have 3 years to file that claim in state court. A division determines the necessary parties and completes the service. So much like EEOC, when you file a complaint with the division, you file it with the division. There's no requirement that you serve it upon the other side. The division will determine who the respondents are. This could include the employer as well as anybody else named in the suit, like say a specific supervisor having conducted specific actions. They may include them as respondent. After they're determining who the necessary parties are, they will serve the complaint upon them. They will request for a response. For the division, all of it can be done online. I always say this, if you Google New York State Division of Human Rights complaint, one of the first 3 links will be their website explaining who to file, the form to use, and the differing offices that you can file within. It is broken up just by region. Again, if you are in New York City, there is New York City human rights law. There is also many offices within New York City. Because it's such a large area, they do have smaller offices, a specific office that handles only the sexual harassment complaints as well. You can do the filings if you want through mail or through fax. They provide all of that contact information on the website. And again, if you file with the New York State Division of Human Rights, they'll do a contemporaneous or simultaneous filing with the commission. So you will have a pending charge opened in both jurisdictions, even though whoever you file with will be the one who does the investigation. Okay, next slide. Similar to how the commission will process the investigation, they are within the division is within the same rights on how they want to process it. Most often, they will take your complaint, request for the respondent to respond. They will send you the response and ask for a rebuttal, so you have essentially the last comment on the issue. But the investigator may also request what's called a fact-finding conference. This, just for awareness, is a situation where the investigator will ask for certain people to attend a telephonic conference. They will kind of go around and ask questions that they have of any of those witnesses. A complainant has the right to be present at all of the questioning during that fact-finding conference. It depends on the investigator whether or not they will let the attorney of the complainant or the attorney of the respondent ask questions during that fact-finding conference. It is important to take notes. Most often after a fact-finding conference, the investigator will let you provide a like a summary memorandum or summary argument regarding, highlights to take away, important things to remember, things like that after that fact-finding conference. But they might also request supplemental information as you go, specific questions or follow-up conferences only with the complainant or respondent. And they will also possibly recommend a settlement conference or conciliation. At any point with the division, you can request to withdraw your complaint. And if a complainant refuses to participate, refuses a reasonable offer of conciliation, or upon your request to pursue, say you want to go to state court, you can request to withdraw and go to state court. The division will dismiss a complaint. Here, as opposed to reasonable cause, the division will issue a determination about probable cause. And if the division finds a probable cause of discrimination occurred, the case will continue before the division to a hearing to be conducted with an administrative judge. The hearing process is very similar to any type of court process where it includes discovery, motion practice, but does not have a jury trial. The division does provide for the possibility of appointed counsel. This is a division employed attorney who can represent a complainant, but there are drawbacks that a client should be informed of, specifically the type of authority that the division may have in that situation to accept a certain type of settlement offer on their behalf, depending on what is offered by the employer and if it addresses more concerns that the division has as opposed to maybe damages rights that the client may have. If the division does not find probable cause that discrimination occurred, that again is not the end. A complainant will have 60 days from the date of the division's decision to take it and file a claim in state court. A minor deadline to keep track that they just kind of throw in that decision is because you have simultaneous filings with the EEOC and the division. If the division does not find probable cause within 15 days of that decision, you could request that the EEOC review it and make a determination on whether or not there is reasonable cause. In that case, if the EEOC does not find reasonable cause, you would get a notice of right to sue. Okay, next slide. So a couple of things that have come up in my practice that I thought would be well warranted to just kind of flag when you talk to individuals about possible complaints or issues that could arise in employment. OSHA, Occupational Safety and Health Administration, OSHA complaints have been a bit popular at the moment. A lot of individuals do tend to ask me about it. This is for private sector, former or current employees, and it does apply to the United States Postal Service. Important to note, former or current. So if an individual is no longer employed there, they can still file an OSHA complaint about that employer. There are two types of OSHA complaints. One is about safety and health. The second is a whistleblower complaint. For complaints, if an individual is calling in about safety and health violations of an employer, OSHA cannot issue citations for anything that occurred more than 6 months. So just, FYI, clients, if they're, disclosing things that happened 3 years ago, OSHA, there's only so much authority that they are given. So the sooner an OSHA complaint is filed regarding safe and healthy issues, the better. For whistleblower complaints, you cannot remain anonymous. Health and safety, you can. The deadline to file whistleblower complaints are dependent on the statute. So I included an example here For safety complaints, if say you're alleging retaliation because you filed a complaint about safety violations, you have 30 days to file a complaint with OSHA. There are, breaking down, many things that OSHA is able to investigate, including consumer produce, motor vehicle, food safety, environmental protection, fraud and financial issues, health insurance, and transportation issues or services. I included the link on the PowerPoint here. If you go to the site there, it does break it down for each category, and it includes all of the laws and statutes that would fall within those categories. It ranges between 30 days to file a whistleblower complaint to, I believe it's 6 years in certain cases. With OSHA as well, all complaints can be filed right online. This is a major trend in a lot of these complaint processes. A lot of them have fillable forms, and you click submit at the end. If we can go to the next slide. And the final thing I will talk about is New York State Labor Law, Section 740. This is the whistleblower statute for New York State. This is for whistleblower retaliation that you can file in state court. It's based on where an individual resides, where the action occurred, or where the respondent has a principal place of business. There are exceptions, but generally speaking, you do have to show that an internal complaint was brought and that there was, an opportunity for the employer to correct it, or they were aware of it before they took some sort of retaliatory action. The deadline to file in state court under Section 740 would be within 2 years of the retaliatory action. And relief that can be granted as part of damages would be reinstatement, lost wages, attorney's fees, civil penalty not to exceed $10,000, and possible punitive damages if a court finds the actions to be willful, malicious, or wanton. Important to note, if the suit is determined by court to be without bases, a respondent in this case can sue for attorney's fees from the complainant. I believe that is all that I had. If we can go to the next slide just to make sure. Yes, in the court.
So this is the second course code. I'm going to read it aloud. In the meantime, if there are any questions for Amanda, please submit them via the chat. Our second course code today is going to be 365895. Again, that's 365895.
So we have a couple questions. As far as, public body, I think I might have skipped over that point. I apologize. A public body under the New York State Labor Law, Section 740, is any type of government complaint. So if you filed a complaint with Congress, with New York State Division of Human Rights, if you filed a complaint with any type of public agency, if you filed, I think, get specific, Congress, state legislature, or any elected local government body. If you filed a complaint in state court or federal court, if you filed or you participated in an investigation with law enforcement, federal or state, and you are seeing retaliation because of that, that would be any type of public body that protected activity will qualify for 740. In terms of Title VII, someone asked for employee thresholds. Is it based on a calendar year? Yes, it would be a 12-month calendar year. I believe the question is, if you're filing against a state employer, can you file against the state in the division, or is it a federal claim? You could file in state court, or you could file a New York State Division of Human Rights complaint. Someone had a question about the deadlines. The complainant may not file a complaint with the commission until the earlier of 60 days after commencement of proceedings under state or local law. This is getting into a very complicated subject. There are things to be aware of for state state employers, such is called a notice of claim. If you have a claim against a state employer, so if you say it's a public school, if you're employed by the county, in instances like that, you do have a notice of claim is something that does pop up before you can file in state court. So there is case law out there regarding whether notice of claim is required when you're filing a New York State Division of Human Rights complaint. In instances where you receive a probable cause finding, whether or not a failure to file a notice of claim within, the certain deadlines is anything to worry about. There are recent appellant decisions that say that it's not needed. However, if you do want to file in state court, you do have to file a notice of claim. A notice of claim is basically putting the employer on notice that you have a potential state lawsuit under, whatever the reasons stated are. That has to be done within 90 days of the most recent incident. And then there are a series of deadlines that you must comply with regarding that claim. Again, I won't get too detailed in that. That's a very detailed and nuanced area. Someone asked if it's better to file first with the EEOC or the Division of Human Rights. I think it varies by the claims you want to bring. The Division of Human Rights, there are many more offices that are handling complaints. I have seen a speedier process with the division and a more connected, I guess, investigator, as opposed to the EEOC, where you could languish for months. Just because the EEOC is handling both private sector and federal sector complaints. They have a much more larger docket to assist people with. So as a division, I've seen it go faster, even though it definitely, nothing is slow in the legal field anymore, or nothing is fast in the legal field anymore. So I usually like to file if it's a private sector employee. I'm going to file with the division and go through that investigation, especially because you still preserve your federal complaint, your federal rights. You can always ask for the EEOC to review the case and go into federal court if that's the route you choose to go. Yes, you can file a complaint with the EEOC. You do not have, someone asked if you have to file first with one or the other. You could file with EEOC without having first filed with the division, and vice versa. They just, once you file one, a simultaneous pleading will be open up, a simultaneous complaint will be open up with the other. The law that covers disabilities for the federal government is the ADA, or I'm sorry, the Rehabilitation Act. It basically says that this way, the ADA applies to federal employees. Okay, I'll turn it over to you, Taylor, if there's nothing else.
Perfect. Thank you everyone again for joining today's presentation, and thank you, Amanda, for presenting. Please ensure that you complete and return your course evaluation and affirmation to CLE@tullylegal.com within 2 weeks to receive your certificate of attendance. Thank you, and I hope everyone has a good rest of their day.